Good afternoon, everyone, and welcome to this presentation on managing insolvency in the supply chain. I'm Christine O'Neill. I'm a partner in Brodie's Government Regulation and Competition team, and I'm regularly involved in bringing and defending legal challenges to procurement processes. I'm joined this afternoon by my colleagues Jamie Dunn and Lucy McCann. Jamie's an associate in the Government Regulation and Competition practice, and he and I work closely together on procurement matters. And Lucy is a partner in our insolvency and restructuring team. We're going to be looking at managing insolvency in the supply chain from a procurement law perspective, but we thought it would be useful to hear first from Lucy, who's going to put the procurement issues in context by just saying a little bit about what financial distress and insolvency can look like. So if I hand over first to you, Lucy.
Thanks, Christine. So, financial distress or insolvency are not technical terms, instead, they are simply descriptive. Insolvency, in its truest sense, means being unable to pay the debts you owe. So, when companies or individuals are unable to pay the sums they owe to creditors, there are legal processes which entities can go through and which are designed to ingather a debtor's assets and make a distribution to their creditors. There are a range of procedures which are designed to achieve this distribution, and the corporate regimes you may have heard of are liquidation, administration, receivership, or company voluntary arrangements. For individuals, the regimes which apply are bankruptcy, individual voluntary arrangements for England, and trust deeds for Scotland. As a result of COVID-19, the government has also introduced the Corporate Insolvency and Governance Act 2020, which brought innovation to the insolvency landscape and introduced new restructuring tools in the form of restructuring plans and moratoriums, which you may have heard of about in the news. The Corporate Insolvency and Governance Act has also introduced other temporary measures, but we don't really need to consider those today. There are legal tests for insolvency, and some of you may be familiar with terms like cash flow insolvency or balance sheet insolvency. These tests are important, and in the context of procurement contracts that you either have in place or are putting in place, these tests can help you identify where insolvency affects your supply chain. So by way of example, cash flow insolvency can manifest in some really tangible ways, which we'll come to discuss at the practical tips section towards the end. You're likely to come across these tangible effects during the period after you have made the award, whereas with balance sheet insolvency, you should be able to identify the issues around that before you make an award. So having said all of that, I'm going to hand back to Christine to start the discussion as to how these issues can affect the lifespan of a procurement contract.
Thanks, Lucy. And if we move on to the next slide, we're going to tackle this by looking at the different phases of the procurement journey. We'll start with the setting up of a new tender. We'll then look at managing current contracts and frameworks, and then we'll come at the end to talk about planning for future procurements with the benefits of lessons learned. So while this session is concerned with what you do with suppliers who are already on contracts and frameworks who may be showing signs of financial distress, we thought it would be useful to begin with a refresh on how to deal with bidders who've experienced financial distress in the past when you're setting up new contracts or new frameworks. So if we just move on to the next slide, the first point I suppose to cover is the question of the financial standing of bidders who may be coming forward to bid for places on a new contract or framework. And there are a number of general principles that you have to bear in mind in those circumstances. The first is the balance between transparency and proportionality. Contracting authorities, universities, bodies who are regulated by the procurement regulations should be very clear about what kind of financial distress will or will not disqualify a prospective bidder. And while extremely comprehensive and rigorous disqualification criteria can be useful because they can be very helpful in satisfying that transparency requirement, there's also the tension that exists between transparency and proportionality. So any criteria that you do put in place in terms of financial standing should be proportionate to the kind of contract that you're trying to put in place and to the market from which bidders are going to be drawn. You will be concerned to make sure that you verify a bidder's financial standing, and that can be done in terms of the regulations by reference to a range of information, including bank statements, financial statements, and annual turnover. But PPN 816 is very clear that you should not deselect potential suppliers on the basis of a credit check alone. And leaving aside credit checks, you shouldn't in other ways, if you like, outsource your decision on financial standing to credit reference agencies. It remains the obligation of the procuring authority to satisfy itself about whether or not someone meets the financial standing criteria. The other general principle, just to remind you of, is that a bidder can rely on the financial standing of other organisations in, for example, consortia or group companies, and it can rely on the financial capacity of another entity regardless of the nature of the legal relationship with that other entity. So in fact, it doesn't have to be a group company, but it can be someone else with whom the bidder has made an arrangement to bid in conjunction with, for example, in relation to a framework or a prospective contract. Again, if we move on to the next slide, and again, we're still in the context of new tenders and bidders looking to be appointed to new frameworks or win new contracts. Again, you will be all aware, I am sure, of the range of discretionary grounds on which a prospective bidder can be disqualified. And really the point for the purposes of this seminar is that insolvency is a ground for excluding a bidder at the selection stage, but it's a discretionary ground for exclusion, so it's not mandatory. That being so, the key point here is that, again, your procurement documents should be clear about how you will approach an insolvency or financial distress situation, and it's as well to be as precise as you can be about that. Jamie and I are involved in a case at the moment where a selection questionnaire did refer to bankruptcy, it did refer to formal insolvency, but didn't refer to an administration situation, and it's not altogether clear whether a bidder should or shouldn't be excluded in that context because they have gone into administration. So Lucy's already talked about the various forms of financial distress that there might be. For the purposes of this exclusion provision, we would recommend that you try to be as precise as you can be when you're dealing with these sorts of issues. Again, there are other discretionary grounds for exclusion, and if we move on to the next slide, these are some of the grounds that might be related to situations of financial distress or insolvency. So it may be that in coming to an insolvency situation, a company has behaved in a way that might fall within the definition of grave professional misconduct that renders the bidder's integrity questionable. Again, that will be a question of fact in the particular circumstances. And again, it's a discretionary rather than mandatory ground of exclusion. There may also be a question about whether there has been misrepresentation in the course of the tender process, depending on what the bidder has said about their own financial situation. And there may also be a situation where you have, again, a discretionary ground of disqualification because a bidder has been guilty of significant or persistent deficiencies in the performance of a substantial requirement of a prior contract, which has led to early termination, to damages, or to other comparable sanctions. Comparable sanctions might in that context be, for example, contractual sanctions like liquidated damages, or indeed other contractual remedies. So again, all of these grounds of disqualification could arise in the context of a financial distress situation. If we move on to the next slide, I think the general points that we would ask you to take from all of this at the new tender stage of the process is that you will have to apply your mind to any bad behaviour, to use that expression, by a potential bidder, and really think quite carefully about whether their prior history is something that you think, as a matter of proportionality, should lead you to disqualify them from the prospective contract or the new framework. And we've also said, again, in the context of new tenders, that one of the things that you should be thinking about when you get to awarding a contract and appointing a new contractor is thinking about how you put together your contract with them to ensure that you do have options to terminate or take advantage of other remedies if a financial distress situation arises. Now, that's really us having looked at the new tender situation. We know you're particularly interested in what to do with existing suppliers when a financial distress situation arises. And if we move on to the next slide, I'm going to pass on to Jamie to talk about managing the contract.
Thanks, Christine. So the public procurement regulations do make allowances for dealing with performance failure in an ongoing contract. In particular, the rules allow the contract to be changed to replace an initial contractor with a different one if that change is the consequence of the new contractor's complete or partial succession into the initial contractor's position, and that follows a restructuring, which includes insolvency situations. That is provided that this does not mean any other substantial modifications to the contract. So what that means is that an insolvent supplier whose business is acquired by somebody else may be replaced by another entity within the new group, for example, the buyer, without the need for the contracting authority to re-procure the contract. And that means there's a potential benefit to you as a buyer if the insolvent supplier is acquired by somebody else. But termination clauses should be drafted into contracts to allow you to walk away and re-procure in these circumstances if, for whatever reason, that is a preferable approach for you to allowing the new owner to step into the former supplier's shoes. So the procurement rules imply termination provisions in some circumstances. For example, where a supplier is convicted of fraud. But even though, as we've looked at a moment ago, insolvent suppliers can be excluded from bidding for a new contract in the first place, these implied termination provisions which affect ongoing contracts do not apply in the case of insolvency events. So you can permit a new supplier to step into your insolvent supplier's shoes. And because you can do it, you will need to do that unless you have prepared for that in a termination clause in the original contract, unless your contract allows you to, at that point, walk away. So what if you choose to do just that? Well, before doing so, consider whether you have enough time to properly re-procure whatever it was that the now insolvent supplier was supplying to you. It's important not to be tempted to consider this as an emergency scenario. Sometimes that can seem like a get out of jail free card, if you like, that would allow you to make a direct award. If the supplier, if your incumbent supplier goes to the wall and nobody buys them, then you may be left in a position where you have to urgently procure a new supplier. And the rules are set up to allow you to make a direct award where there's no time to put together a new compliant process to replace your insolvent supplier with somebody else. However, the key thing here about the rules on emergency procurements is that they do not allow you to do that when the urgency that stops you going through the full gamut of procurement rules, where that urgency is of your own making. And that may well be the case in circumstances where the contract and the practical situation would have allowed the buyer or whoever took over the incumbent supplier to succeed into that position of the insolvent bidder, insolvent supplier, and you just chose not to let them do that. So if you do want to terminate, it's important to make sure that you've built in enough time to re-procure the contract and that the incumbent supplier is still able to provide any essential services in the meantime. Bear in mind that it might be that it's your decision to terminate a contract that is what finally pushes a current incumbent supplier over the edge. and into insolvency or into a similar situation. Contracts for essential services will generally oblige the supplier to carry on until a new supplier is in place, including making provision for any transition and handover requirements that might be necessary. But that legal obligation you will find to be of little use in practice if the supplier is unable to pay their employees or their own suppliers, and therefore is simply left unable to do the job. So it's just worth being careful about pushing too far ahead too quickly, in case that is, as much as anything, what just makes the problem worse. Multi-provider frameworks can provide a way of de-risking in insolvency situations and in advance of insolvency situations by allowing alternative providers to be used. And the call-off terms under frameworks should be drafted in a way that allows for that to be done. A note of caution about the use of frameworks more generally, though: the only supplier that can be instructed off of a framework is the one whose name appears on the framework. And the sort of totemic case for this is one called Lightways against Inverclyde Council, where a court gave a declaration of ineffectiveness against a contract between the council in question and a company called AME Public Services LLP, because the AME entity that was actually listed on the framework and therefore was available to be contracted with by the council was AME OW Limited. Because the company that was contracted with was not the same entity that appeared on the framework, that made the call-off contract an unlawful direct award. So it's important to note that if you have a company on a framework that you are using that gets into difficulty and you find yourself concerned about their reliability going forward, you cannot simply appoint a different company from the same group off of that framework. You would need to be looking at the rules around modification that we covered a moment ago, or just looking at reprocuring from scratch. Now, clearly the ongoing pandemic has presented a number of issues to buyers. There may be a need in future, for example, to change the way that we look at force majeure clauses. The key thing to mention here is what scope you have to respond to this type of situation under procurement rules. Modifications of existing contracts may be necessary, for example, to change payment dates, milestones, and so on. And that may be both because the rules in place imposed by government around people moving around have made certain performance impossible, but it can also be simply because suppliers have struggled to perform as required, whether financially or otherwise. So contracts should allow for certain requirements to be adjusted or waived, and you should make as much use of those as you think is appropriate in order to work in partnership with struggling suppliers, and through that collaboration try and avoid any difficulties arising in the first place, or at least mitigate them. But be careful with the use of, be careful with modifying contracts. Firstly, the modifications that change the economic balance of the contract in favor of the supplier, for example, by shifting risk from them to you, rather than the other way around, or by removing or waiving liquidated damages clauses, for example, in a way that the contract does not allow for, are not permitted by the public procurement rules. And a contract that is modified in such a way could constitute an unlawful direct award of a new contract. And the reason for that is essentially that when everyone was bidding for a contract in the first place, they were looking at the contract as it was advertised. And if later on, for whatever reason, you find yourself modifying that contract, you may be modifying it in a way that, had that been the case when the contract was initially advertised, different people might have applied, might have bid for it, and different people might have won it. And therefore, the public procurement rules don't allow you to do those types of modifications midway through a contract. There is another exception for this, which is that contracts may be modified in line with public procurement rules if there is a clear, unequivocal modification clause within the contract. So that may be something to think about in advance, is allowing yourself the leeway to do that type of thing. But if you have not, then it's important not to overreach. Doing too much to help your suppliers, particularly without a clear review clause to rely on, may inadvertently cross that line. In the same way, be careful about continuing to pay suppliers regardless of their performance, as you may be stepping into the realm of state aid or subsidy control there. So to give one example of this, we advised a local authority during the height of the pandemic that wanted to keep paying a supplier, in this case, in the context of services that had been outsourced, where the employees were former council employees, even though lockdown prevented the supplier from delivering any services, because what the council wanted to do was support the supplier to keep those staff on 100% of their salaries during furlough. Now, that wasn't possible in the circumstances because the financial support that the council was trying to give the supplier wasn't tied to any part of the contract, and it wasn't tied to any services that were being provided. It was effectively, therefore, just a selective grant. The council was really just trying to provide money to subsidise the wages of that supplier's employees because those employees were former council employees. And so that's the type of situation where you move beyond the scope of paying somebody under a procured contract, and really all that you would be doing is giving them public money. And because of that, you would be straying into the realm of potential subsidy problems. That's both under state aid law that we've become used to, but also under the newly applicable rules under the Trade and Cooperation Agreement and the Subsidy Control Framework, which are about to be elaborated on. And then finally, we wanted to note here that it's worth bearing in mind that TUPE issues can arise where a new supplier steps into the shoes of a former or of the incumbent one. Whether or not they are acquiring the former supplier's business, TUPE obviously is concerned with employees that were performing certain set tasks, and as those set tasks are reprocured around different suppliers, the employees can move with them. It's important, therefore, to be upfront with potential new suppliers in discussions about whether that is something they will have to do, and that may well be something that they are particularly keen to ask you about before they get into the potential risk of taking people on, particularly taking on people that that are about to lose other jobs with a now insolvent supplier. So those are really the main issues to cover around how to manage when things get into difficulty during the life of a contract. But then I'll hand back to Christine just now to talk about how to learn lessons from that in future procurements.
Thanks very much, Jamie. Very helpful. And I'm conscious that we have a few moments left. And if we move on to the next slide, we are going to talk about lessons learned. I just want to bring Lucy back into the discussion. I'm conscious that a number of those who are watching this session may be wondering how they can spot at an early stage a potential problem with a supplier. So do you have any practical tips, Lucy, for delegates on how to spot financial distress at an early stage?
Yeah, no, thanks. And I think the thing to remember here is, the universities who'll be thinking about these issues, and they'll be dealing with a whole range of different types of contracts. So the red flags that I'm going to be mentioning, might not apply to every contract, but or every supply, but it's worth just kind of bearing these in mind overall. So, for example, the things that will manifest will be suppliers not performing to their usual service levels. Perhaps they have less staff on the job, or there's a higher turnover of staff depending on the type of contract that it is. All of those kind of indicate that the company's not perhaps managing to retain staff. Is that an indicator of financial distress? They might be dilatory in settling invoices or dealing with financial matters. Other red flags could include, an unresponsiveness from senior management levels. Again, that just may be an indicator that the business itself is in some financial turmoil. So those are the types of things that you'll normally be looking for, and you need to be quite intuitive and really tune in and understand what's going on with your suppliers.
Thanks, Lucy. So that's a practical set of things that can be done to spot financial distress coming at you. Jamie, in terms of preparing for that, are there any other practical things that delegates should be doing to reduce the likelihood of problems becoming a reality?
Yeah, I think the key consideration is really spreading the risk and not relying too much on any particular supplier. No supplier is too big to fail ultimately, and allocating your contracts to a spread of suppliers will mitigate your exposure to any one of them in particular. So I would certainly suggest making sure that you understand who your suppliers are. So look above the suppliers themselves to understand the corporate group that they are a part of. Some large businesses will operate under many different brands and bid for contracts under many different subsidiaries, but there may be a potential exposure to some sort of domino effect if economic difficulties arise within a group, and you may not necessarily have mapped out the full impact of that on your business, just simply given how broad and wide some of these companies are. I would also say consider using frameworks, consider breaking big contracts into lots, and consider what you can do to build market capacity as well. Spreading contracts between more smaller bidders may sort of increase some of your administration costs. You may find yourself dealing with more people, but what it does certainly do is reduce your exposure to the financial difficulties that might affect any one supplier. And if you find that there's a given market that you are trying to buy things from where there are a limited number of suppliers, consider whether grants, for example, could be used to support new entrants in getting involved in those markets, perhaps in parallel with procured contracts, and use that type of mechanism, which is certainly encouraged in procurement guidance. Use that type of mechanism to get them into a position where they can bid for other contracts in the future.
Thank you, Jamie. So to wind up, I think we're all conscious of some of the stresses that have been put on the supply chain over the last 18 months or so. Does supply chain integrity matter? Well, of course it does, but I think we all recognise that sometimes problems can exist on such a scale that even procurement law doesn't have a solution to those problems. And one of the things that's been clear over the last period is that force majeure clauses, which we've mentioned, have not necessarily coped terribly well with the kind of situation we've had where business has not stopped entirely, but has had to be delivered in quite a different way to how it was originally envisaged under a contract or a framework. And that does lead us to think that force majeure clauses do need to be looked at again to think about whether they really are fit for purpose for the kind of experience we've had in the last little while. We always encourage good business continuity planning, and we hope that everything that we've said in the last half hour or so has helped you to think about some of the things you might want to include in your business continuity planning going forward. So thank you very much for your attention this afternoon. We hope this has been useful. These are the people at Brodie's who can help with procurement and insolvency issues if they arise, and we look forward to working with you soon.